All right. Cingolini. You know what the important thing to me in Cingolini is? It really has nothing to do with just restoring the way the law was previously. The key part in Cingolini is this section here. Look at this language by the court. This comes at the end of the decision, and it's in dicta. That said, we need not decide in this case whether a person can twice take advantage of a step-down. Defendant's refusal conviction cannot be considered as a prior DWI for enhancement purposes, and thus she is not precluded from the benefit of the step-down under 39-4-50 for a prior DWI, because her first DWI conviction was more than 10 years prior to her second, the 2008 DWI conviction. Now, I have to tell you, although this isn't directly discussed in the Burroughs case, I've always taken the position that if you qualify in terms of the time breaks, there's nothing to prohibit you from getting 2 step-downs in your lifetime. So, you know, your first offense is in 1980, and you get arrested the second time in 1991, you're entitled to a step-down. Then you get arrested the next time in 2008, it seems to me you should be entitled to a second step-down, because just by the look at the statute, your third offense is more than 10 years after your second offense, which is precisely what the statute says. So I was a little bit surprised that the court actually reserved on this issue. So I just kind of bring it to everybody's attention for 2 things. Number one, that you may get this thrown in your face if you have a situation where your client previously had a step-down and you're qualified for it again. You're going to have to litigate this, and this may be something that's going to have to go either to the Appellate Division or be on the fast track to the Supreme Court, since they specifically reserved on it, okay? It's kind of buried in the opinion, but it's something very important for you all to know about. And cross-reference this in your notes to State versus Burroughs, which is that's the main case dealing with step-downs under New Jersey law. Okay. The next case, State versus Lawless, requires a little bit of a background discussion, just so you'll be able to appreciate the case in some type of context. I want to start with State versus Moran as the beginning part of this. Moran, of course, being the Supreme Court decision from 2010, which created a list of aggravating and mitigating factors that judges are to utilize in sentencing in municipal court in non-criminal matters. Now, it was very narrowly construed in the Moran case because it dealt with a specific issue dealing with 39-531. Under what circumstances can the judge suspend a license for a willful violation of the Motor Vehicle Code? And at the end of the day, Justice Alba, when he's writing the decision, says when judges are going to decide whether or not to suspend a license in the first place, they should be utilizing these aggravating and mitigating factors. And number 2, when they're thinking about the length of the suspension term, they should also utilize the same analysis, same aggravating and mitigating factors. And the list of the factors tracks very carefully the same aggravating and mitigating factors that you would see in 2C44-1, in the criminal code, except that they're kind of changed to be oriented toward motor vehicle offenses, okay? Now, what happened after the publication of Moran, we were in a rule cycle, and the Supreme Court Committee on Municipal Courts got a hold of this, and they made a recommendation that Rule 7:9-1 be amended to kind of incorporate the holding in the Moran case. So this is a brand new rule, 7:9-1C, and it requires that in non-criminal code sentencing that judges must consider the aggravating and mitigating factors, and it expands the kind of the classifications where they have to consider them to pretty much everything a judge would have: the amount of the fine, the length of a jail term, the amount of restitution, and, of course, license suspension and length of license suspension. So pretty much everything is in play now based upon these aggravating and mitigating factors. And it would apply under the 7:9-1C not only to traffic tickets but to other types of non-criminal code sentencing, ordinance violations, and I guess you would run into it also with, like, fish and game and things of that nature where judges will do sentencing in municipal court. But the largest majority, it's going to come up in the context of traffic. That's number 1. And number 2, the court rule limits it to consequence of magnitude situations. So in the normal careless driving case, it's not necessary for judges to go through this analysis, but it's mandatory in those instances where the judge is going to be imposing something that constitutes a consequence of magnitude. All right? By the way, have you guys noticed that John was here? All right. Now, one of the issues that we have to kind of deal with, and this is where this lawless comes in, is in the drunk driving context, to what extent can you consider, in terms of aggravating and mitigating factors, the defendant's blood alcohol concentration, okay? And let's face it, you're guilty at a .08. So does it really matter, with the sole exception of the amount of license suspension you're going to get and whether or not you're going to get an ignition interlock device put on your vehicle, whether you're .08 or .17 or .24? I mean, should it matter? Does it really make any difference? The argument I had made for a long time comes out of this Crumpholt decision, a decision by the New Jersey Supreme Court, which says that in the context of determining how reckless an individual was in a case that has recklessness as an element in the criminal context, the defendant's BAC is really double counting. You're taking an element of the offense and counting as an aggravating factor, which is it's not appropriate conduct to do. Okay, you can't utilize an element of the offense as an aggravating factor. This is double counting. The case on that is a case called State versus Yarbo, which is reported at 100 New Jersey. Okay, so that's kind of the argument that I had made for a long time. I utilized it in a law division case, which was published under the name of State versus Henry one time, and kind of got rejected on it, but the case never really went anywhere because it was only law division, and we didn't proceed up to the appellate division. Well, this precise, discrete issue has now been addressed by the appellate division in this case of State versus Lawless. And I want everybody to be familiar with it so that when you get to a situation where someone is being sentenced either for drunk driving itself or alternatively for some type of offense and drunk driving is part of it, how do you treat the BAC and the facts and circumstances surrounding the drunk driving case itself? And Lawless tells us how to do it. First of all, there's a description in the case as to when you talk about victims and the rights of victims and how victims should be taken into consideration in sentencing. Family members of victims are basically not to be included in the mix of people who have a right to come in and make victims' impact statements. This is the 2C44-1A. I'm going to just go through the factors that you can see and then go back and show you how the drunk driving parts of it work out. So, gravity, seriousness of harm inflicted on the victim, including whether or not the defendant knew or reasonably should have known that the victim of the offense was particularly vulnerable or incapable of resistance due to advanced age, health, etc. The holding of this case is going to be that this victim means victim and does not necessarily mean victim's father, brother, uncle, aunt, cousin, and other extraneous family members of the victim. Okay? Victim means the actual victim of the offense. Here is the explanation of the law division, the appellate division. We've located no case in which a court has approved consideration of direct effective defendant's action on people other than the victim of the offense for which a defendant was being sentenced. So if you get people who are, in court and they want to kind of shoot their mouth off and have all kinds of inflammatory stuff about your client if you're defending somebody, unless they meet the definition of a victim, you've got to be objected to them testifying at trial. In fact, we've previously held that aggravating factor number 2 relates only to harm inflicted on the victim of the offense, not the family. We stated the wording of 2C44-1A2, which includes consideration of the victim's power of resistance, indicates the legislator intended this aggravating factor related to harm inflicted on the victim of the offense rather than the victim's relatives. Okay? Keep that in the back of your mind. I refer back to the state constitution. This is my notes here to answer that precise legal issue. Because Article 1, Paragraph 22 of the Constitution says, for purposes of this paragraph, a victim of crime means a person who suffered physical, psychological injury, etc. But where's the part about when people get killed? Okay. Okay. B, the spouse, parent, legal guardian, grandparent, child, or sibling of the decedent in the case of a criminal homicide, which is going to include a drunk driving case, where there was a homicide as well. So I'm not sure the appellate division really was thinking about this, because constitutionally this is going to take precedence over what they said. But that's a good catch. That's exactly what I was thinking. All right. Risk the defendant will commit another offense. The judge also applied aggravating factor number 3, the risk that the defendant will commit another offense. In so doing, he referenced defendant's substantial history of driving while intoxicated, and in some instances while his license was suspended. A judge may consider a 39-450 conviction as part of the defendant's overall personal history, as well as pertinent to the risk that the defendant would commit another offense and the need for deterrence.